Hi, I'm Tim Engelbrecht from Butler, Weimuller, Katz & Craig. This presentation is about assignment of insurance benefits following the hurricanes of Harvey and Irma. The hurricanes hit the Gulf Coast and also devastated part of the eastern seaboard. All the states from Texas, Louisiana, Florida, Georgia, South Carolina, and North Carolina were impacted. Insurance companies will begin, if they have not already, starting to get claims from those losses. Many of those claims may come in the form of an assignment of benefits. The purpose of this presentation is to clarify what an assignment of benefit claim is, talk about how the states that I just mentioned handle assignment of benefit claims, and then give specific strategies on how to handle those claims as they come in. Let's take a moment to talk about exactly what an assigned benefit claim is. They're typically referred to as an AOB, assignment of benefit claim. The typical situation often plays out like this. An insured, whether it's a residential property owner or a commercial property owner, has a loss. The loss might be due to plumbing, roofing, or other perils. After the property is damaged, the insured will typically seek out a repair contractor. In fact, the insured might seek out many repair contractors or contractors to prevent further damage to the property. Those contractors will typically come to the property, see what needs to be done, and then ask the insured to execute an assignment of benefits. The purpose of this is for the contractor to know that he or she will get paid by the insurance company for the work that they're about to do. Oftentimes the work is urgent and needs to be done right away, so the assignment of benefits contract gives the contractor confidence that they will get paid later by the insurance company. Typically, the assignment of benefits contract is a one-page document and says something to the effect of, for and in consideration of the insured assigning insurance benefits to the contractor agrees to provide services at the property and be allowed to bill the insurance company directly. In that sense, the assignee contractor stands in the shoes of the insured. That's the typical assignment of benefits scenario. Now let's talk about how the states that I mentioned earlier, namely Texas, Louisiana, Florida, Georgia, South Carolina, and North Carolina, each deal with assignment of benefits. I can tell you that the states deal with them differently, so it's important to know how your state deals with them. We'll start with Florida. Florida has had the most assignment of benefit activity of probably any state in the union over the last 5 to 7 years. Therefore, it's important to focus on what Florida does because many other states follow what Florida does. In Florida, an insured has had the right to assign post-loss benefits to a contractor for over 100 years. Florida court decisions have stated that an insured's right to assign benefits away will be protected, even if an insurance policy has an assignment or anti-assignment provision. Most insurance policies have a provision of that nature that says something to the effect of, we will not allow an assignment of this policy without our express written consent. The way Florida courts have dealt with that is by saying that an insured cannot assign the entire policy to somebody other than themselves prior to a loss, but instead an insured can assign away a claim for post-loss benefits because that claim has already accrued. Florida allows insureds to assign virtually any post-loss benefits to a contractor, and those assignment of benefits will be upheld. Now let's shift our attention to a different state, Texas. Texas actually takes the opposite approach. Texas law says that an insured cannot assign away benefits, even post-loss benefits. Texas courts have interpreted the anti-assignment or assignment provision in most insurance policies to include a prohibition on post-loss assignments. Therefore, even if a policy has the general anti-assignment language in it, Texas will enforce that against even post-loss benefits. So in that regard, Florida and Texas handle assignment of benefits very differently. The next state I want to talk about is Louisiana. Louisiana takes a hybrid approach. The Louisiana courts have stated that insurance companies can place a provision in their insurance policy that prohibits post-loss assignment of benefits, but in order to do so, that provision must be very explicit. This ruling came from the Louisiana Supreme Court as they dealt with a number of cases born out of Hurricane Katrina. What the Louisiana Supreme Court said is that the broad general anti-assignment provision that typically has appeared in insurance policies is not specific enough to prohibit post-loss benefit assignment. However, if insurance companies write a more specific provision in their insurance policies, explicitly and unambiguously excluding post-loss benefits, that will be upheld. Then we can look at the 3 states on the eastern seaboard that were also affected by Hurricane Irma. They are Georgia, South Carolina, and North Carolina. For the most part, these 3 states address assignment of benefits fairly similarly. Like Florida, they allow assignment of benefits, and assignments of benefits will be upheld in those states. That's a look at the states that have addressed assignment of benefits that have been impacted by Hurricane Harvey and Irma. Now I want to talk about how adjusters and insurance companies should approach handling assignment of benefit claims. First and foremost, as I've just highlighted, it's critically important that you know how your state addresses assignments of benefits. If you get an assignment of benefit claim in Florida, that claim will be valid, and the insurance company will have to deal with the assignee contractor who has received the assigned benefit claim. In Texas, assignments are not allowed, so an adjuster or an insurance company will need to reconnect with their insured to determine how this contractor fits into settling their claim. Second, it's important for an adjuster or an insurance company to read the actual assignment that comes with the assigned benefit claim. For example, if a contractor calls the insurance company and says that they have received an assignment of benefits from the insurance company's customer, the adjuster will need to carefully look at the assignment itself. As I said, these are typically a 1-page document. However, many times they are not the same. For example, an insured may have had a loss and suffered water damage at their property. The insured may have hired a contractor to extract the water from the business, but the insured may keep the remaining rebuild claim for him or herself. In that instance, only part of the claim has been assigned away to a contractor. In other instances, an insured may hire a contractor to do both remediation, protection from damage from the property, as well as rebuild the property. That assignment of benefits will look a bit different. It's also possible that an insured could assign benefits to multiple contractors. Perhaps one contractor will be doing damage prevention, and a second contractor will be doing repair work. Again, it's important for the adjuster and the insurance company to read the assignment of benefits clearly and carefully. If it's not clear what the assignment has assigned, it's important for the adjuster to connect with the insured and the contractor to make sure everybody's on the same page. Third, it's important for the insurance company to connect with the insured regardless. Whenever an assigned benefit claim comes in, it's important to know what happened and why that work was needed. An insurance company's insured is its customer and oftentimes its best resource for figuring out what the damage was, why the work was done, and why the repair contractor has the assigned claim. Many times an insurance company will need to investigate the claim, and in some states, an insurance company is not able to do that through the contractor. For example, in Florida, it's unlikely that an insurance company can compel an assignee contractor to satisfy the insurance policy's post-loss obligations. These are oftentimes a request for documents, examination under oath, or a sworn statement in proof of loss. However, Florida law is reasonably clear that an insurance company can get these same items from its insured even for an assigned claim. In that instance, the insurance company can get information from the insured, including an examination under oath or documents, to make sure that the insurance company understands the assigned claim and the contractor's claim. In fact, if an insured fails to cooperate with the insurance company on these post-loss requests, it may impair the insured's claim, and it may also impair the assigned claim. Fourth, once the insurance company has determined how it will pay the assigned claim, it's very important to make sure that the insurance company has a very good idea of who needs to be on the settlement check. Oftentimes, a settlement check may be payable to both an insured and a mortgagee. However, after a complete assignment of benefits, it may not be proper to have the insured on the payment. It may only be proper to have the assignee on there. If there has been a total transfer of rights, the insured may not need to be on the settlement check. Another important aspect of who goes on the settlement check is whether or not the work has been done or if it will be done in the future. It's also important to know whether the work is to prevent further damage or to repair existing damage. An insurance company may need to reach out to any mortgagees as well to determine if they need to be on the settlement check. Some contractors will argue that because their work is just damage prevention, a mortgagee does not need to be on a settlement check for damage prevention work. They also argue this is true also if the work has been performed. Our recommendation is for insurance companies and adjusters to always speak with any potential mortgagees to ensure that when they issue a settlement check, it includes everybody who should be on it. Fifth and finally, it's important for adjusters and insurance companies to know whether or not they can invoke an insurance policy's appraisal provision to settle an assigned claim. Most insurance policies, or certainly many, include an appraisal provision. That provision usually says, if you and we disagree on the amount of your loss, either of us can invoke the appraisal process, and two of the three appraisers and umpires involved will set the amount of loss. There are questions that are raised when there's an assigned claim as to whether an insurance company can demand appraisal or whether an assignee contractor can demand appraisal. These issues are still working their way through the courts, but in Florida we have one decision that strongly suggests an insurer can still use the appraisal provision to determine the amount of loss even for an assigned claim. Looking back, we will all remember Hurricanes Harvey and Irma and the impact that they had on the Gulf Coast and the southern eastern seaboard. Insurance companies are dealing with many of these claims now, and we certainly anticipate that they will be over the years to come. Assignments of benefits are a challenging issue. When compounded with 2 hurricanes, we anticipate that those challenges will only grow. It's important for adjusters and insurance companies to understand how to handle assigned claims. We have been helping adjusters and insurers navigate the tricky issues of assignment of benefit claims for many years. Please contact us if you have any questions.